My name is George Lee, and I am an attorney at Seiler Epstein LLP in San Francisco. Now, I flew in from San Francisco yesterday, so the good news is that apparently San Francisco hasn't enacted a terrorist no-fly list yet, so... Think of my office as your outpost on the frontiers of liberty, surrounded by hostile and angry tribes. That's me. It is my great privilege and pleasure to be able to represent organizations like Second Amendment Foundation, Firearms Policy Coalition, CalGuns Foundation, and others in various state and federal litigation that we have going in California. And I would like to talk to you today about 3 cases that we and SAF have in California and give you the status of those. The first case I'd like to tell you about is a case called Wies versus Becerra. And Wies was the first filed challenge to California's large capacity magazine ban, which we filed in October 2017 after the California legislature enacted a oppressive package and relentless package of gun control measures, which we now not so fondly refer to as Gunmageddon. And the status of our case, Wies, is currently stayed pending the outcome in a similar case brought by the California Rifle and Pistol Association called Duncan versus Becerra. And I'd like to take a moment just personally to point out the excellent work that attorneys Sean Brady and Anna Barvier did in that case to get a favorable ruling from the judge in enjoining the large capacity magazine ban. So our case, Wies versus Becerra, is stayed pending the outcome of that case in the Ninth Circuit. But there are some differences that I'll just briefly mention to you. Our case, Wies, does have additional claims that are not presented in Duncan, including a vagueness claim. Now, without getting too technical and into it, because I realize it's late in the afternoon, there are currently 2 different versions of the large capacity magazine ban that are chaptered, and look it up, that one version of which has exceptions. For example, if you have a firearm for which they never made a magazine that holds 10 rounds or fewer, that could be an exception. The other version, there are no such exceptions. Both are currently live active statutes. Which one's correct? I don't know. I guess we'll let the Ninth Circuit decide that someday. That's going to be irrespective of what happens in Duncan. And the other one is a challenge on equal protection grounds to the Hollywood exception, which allows an actor like Matt Damon to rant with anti-gun speeches during the day and take a large capacity magazine home at night simply because he's a Hollywood actor. But if I may just divert for a minute about the legal aspect, I think the lesson of California's large capacity magazine ban is that when they say, well, we'll grandfather these things in, don't believe them. It's a false promise. Because the fact of the matter is, in 2000, the California legislature banned the importation, sale, manufacture of new large capacity magazines. But they said, I guess to paraphrase Obama, if you like your magazines, you can keep your magazines. But 18 years later, not so much Obama, now it's Darth Vader. We have altered the deal. Pray that we don't alter it further. So the lesson of California's large capacity magazine ban is when they tell you that grandfathering will lessen the sting of these measures, don't believe in their false compromise. The second case I'd like to tell you about today is a case I'm excited about. We just filed it. It's a case called Miller versus Becerra. And this is a case that is currently in front of Judge Benitez, who gave the plaintiffs a favorable ruling in the magazine case. And this is a challenge to California's assault weapons statute, once again. And this one is going to be based on features. Right now, it starts with magazines, which are a feature, of course, but it's going to include all the standard AR-15 features: flash hider, collapsible stock, pistol grip. And I would like to thank the San Diego County gun owners for their ability to mobilize and organize very highly motivated people who can bring these types of claims. The goal in Miller is very simple. It is to restore the command of Heller, which states that governments may not ban by category firearms that are in common use for lawful purposes, such as self-defense, sport, or defense of country. And contrary to what they may say in the sheltered enclaves of San Francisco and Los Angeles, they don't have to drive very far, by the way. AR-15 rifles are indeed commonly owned by Americans of many stripes. And our own California Department of Justice estimated that from 2001 to 2016, there were an estimated 1.5 million legally owned firearms that they classify as assault weapons in California alone. So it is our hope that maybe someday, once again, a case called Miller will stand for the proposition that if it's good enough for militia service, it's good enough for an ordinary citizen. The third case I'd like to tell you about is a very interesting case. It's a case called Linton versus Becerra, and it's an interesting case based on undisputed, straightforward facts. Two gentlemen had nonviolent felony convictions from a long time ago in the states of Arizona and Washington, and those felony convictions have been set aside, vacated, and in fact, the judges of those states expressly ordered that these gentlemen have their Second Amendment rights restored to them. Now, notwithstanding these court orders from Arizona and Washington, the state of California simply refuses to recognize those court orders and considers these two gentlemen to be prohibited persons. So we've sued under a number of theories, including the Second Amendment, the Full Faith and Credit Clause of the Constitution, the Privileges or Immunities Clause of the 14th Amendment, and it might seem like small ball, but this is a case that matters. And why does it matter? Well, two things. First, this is actually a situation that occurs more often than you think. Ever since we filed the case, I actually get a number of calls, people saying they're in that same position. They have an out-of-state felony conviction that's been vacated or set aside, and California still's denying them the right to own a firearm. But the second reason why this case matters is because what we're trying to do is roll back this mentality that rights are special privileges that the state can grant or deny at whim. The Attorney General in our case, in fact, confirmed this mentality when they said in their motion to dismiss our case, they said, quote, "The complaint's allegations center around two individual plaintiffs who each contend that they deserve this special treatment because an out-of-state court allegedly has set aside their felony convictions." They think that your Second Amendment rights are special treatment. So this is why we fight, and this is why we bring these lawsuits, and this is why we will restore the Second Amendment one lawsuit at a time. What's it like to bring Second Amendment cases in courts in California? Well, I like to think of our situation, without getting too grandiose about it, I like to think of our situation as like that battle off Samar during World War II, which took place in October 1944, where a small group of US destroyers and escort carriers were surprised all of a sudden to find that they were the only force between our landing forces at Leyte Gulf and a Japanese fleet that came out of nowhere with battleships, cruisers, and destroyers. To suddenly find this force bearing down on them. And what did these American destroyer captains do when they were confronted by this overwhelming enemy force? The American destroyer captains laid down smoke and headed straight into the oncoming Japanese fleet. In the words of the late great writer Herman Wouk, who wrote of this battle through the voice of a fictional character, said, quote, "The vision of these three destroyers charging out of the smoke and the rain straight towards the main batteries of Korea's battleships and cruisers can endure as a picture of the way Americans fight when they don't have superiority. Our school children should know about this incident, and our enemies should ponder it. In our fight and against these forces, let us endeavor always to lay down smoke and turn towards the enemy in a manner that our school children will remember and thank us for, and that our enemies will have to ponder. Thank you.
If you like our videos, follow, subscribe, like, and share.